India Legal, stories that count.
Hello and welcome to another special readout from India Legal magazine. As you know, we are the nation's first political legal magazine, independent political legal magazine focusing on controversial issues of national and international importance. The video readouts we present to you regularly are the editorial team's choice of the most significant stories we believe should receive close scrutiny and wide circulation. You can watch them along with the visuals or listen to them as you would a podcast. In this commentary, we focus on India's investigative and policing agencies. They have ostensibly been created to catch crooks and protect us from the ravages of organized crime. Are they a necessary evil? When functioning as they are supposed to, they are necessary. Yes. Evil? No. But over the years and across different governments elected to power, serious aspersions have been cast on their role and activities. A recent India Legal TV show hosted by APN Chief Editor Rajshri Rai focused on the political use of central investigating agencies by ruling parties. Editor Sanjay Raman Sinha, who covered the event, reports that the recent actions of the central investigative agencies have raised accusations of vendetta politics. A few days after the Enforcement Directorate, that's ED, arrested Delhi Minister and Aam Aadmi Party leader Satyendra Jain in a money laundering case, Sonia and Rahul Gandhi, who run the Congress party, the nation's oldest party, was summoned in connection with the National Herald case. They have been accused of misappropriation of funds. The list of opposition leaders who are being probed by central agencies is long. It is necessary for these agencies to investigate corruption cases. But since the investigation is mostly confined to the opposition leaders, the matter starts looking suspicious. The investigation goes on for years and cases are closed and opened as per political expediency. Charges of political coercion fly thick and fast in the air. The opposition may attack the use of central agencies for biased investigation, but when it is in power, such voices become silent. The party in power then uses agencies according to their own political needs. Now, G.K. Pillai, former Home Secretary, strongly commented on this trend. Now, listen to what he says. All the heads of the agencies are bound by the rule of law and the Constitution. If these agencies are misusing the law or are using it for political purposes, then they should be hauled up in a court of law. If you are depriving someone of their constitutional rights, then they should be penalized. The department head should be made accountable for the misdeeds and, if need be, even sent to jail. Unquote. The Central Vigilance Commission, CVC, has superintendence over the investigation of cases registered under the Prevention of Corruption Act of 1988. For other matters, supervision is done by the Department of Personnel and Training, that's the DOPT of the central government, which comes directly under the Prime Minister's office. This is the reason why questions often arise on CBI regarding investigation of political cases. N.K. Singh, former CBI officer, spoke from personal experience, and I quote him. During the reign of Lal Bahadur Shastri, former PM, when he was Home Minister and of course later Prime Minister, the CBI was in its golden period. In 1963, CBI was established. It was formed to fight corruption. L.P. Singh, ICS and B.P. Kohli, the first directors of CBI, helped in sterling performance of the organization in its initial years. Shastri, the Prime Minister, succeeded in making the CBI an impartial investigative agency, and then the emergency days came and CBI and Income Tax Department were politically misused. Sanjay Gandhi was the de facto authority and interference was at its peak. Then, during the reign of Morarji Desai, again, the CBI workings actually improved. This is his quote. Income tax is another department which is often in the headlines for its raids. The purpose of an income tax raid is to seize and curb illegal wealth or black money. However, the rules are complicated and are prone to misuse. Now, D.P. Semwal, former Principal Commissioner of Income Tax, IRS, he contends, and again I quote him directly, laws and procedures of income tax is not that it can be misused for long without gaining notice. The officer in charge of a particular case has to do ground research and prepare a satisfactory note before a raid. This note is submitted to a higher official to review. The DI investigation cross-checks the facts, and then the report is submitted to the Director General, who finally gives assent to the raid. Thereafter, raid warrants are made and officials assigned to the raid. The taxpayer can, however, object to the raid and move the court. There have been instances when the court has asked for satisfaction note from the department to satisfy itself of the charges. The new Direct Taxes Code is more complex than the Income Tax Act of 1961. There are many income tax laws which are variously interpreted by experts. A search is generally carried out when there is a continuous non-compliance on part of the assessee to attend the summons received from the department, or showing negligence towards the IT. A survey, on the other hand, is meant to discover assessees who could have been in the limelight but have been managing to avoid on-site investigations. So therefore, these investigations help in gathering information, including conducting inspections of stock and cash. After apprehension, the ED or CBI usually asks for custody of the accused, ferreting out relevant information. Semwal says, I don't agree with the assertion that income tax laws are complicated and hence prone to misuse or manipulation. In fact, the Indian Penal Code is equally open to diverse interpretations, and very often the accused pin hope for acquittal from successive courts. As demand for custody for further probe and evidence collection, it is not incumbent on the Enforcement Directorate to know the whole process or scam or money laundering in a particular case in order to initiate action. By taking note of only a few wrong entries, a case can be made and custody demanded for further interrogation and evidence, or the collection of evidence. The IT department too has been quite active. However, its conviction rate is dismal. In the financial year 2019, 570 of its prosecution cases were disposed of by the courts, but it managed to secure only convictions in, say, I think it was 105 cases, which is less than a 20% success rate. Under PMLA, that's the Prevention of Money Laundering Act, the Enforcement Directorate had conducted over 1,700 raids from March 2011 to January 2020 in connection with 1,569 cases. However, the ED has managed to secure only 9 inconsequential convictions. Justice Dr. Satish Chandra, former judge of the Allahabad High Court, he had something interesting to say. Again, I quote him directly. Income tax looks at undisclosed income. If tax is not paid, then penal tax is demanded. I have looked at the conviction rate of income tax departments, and in many cases, irrelevant income figures are taken into consideration. The income tax department is selective in its targeting. Many prominent political figures have been overlooked for their trespasses. The opposition may attack the use of central agencies for investigation, but when it is in power, such voices become silent. They indulge in similar misuse. I suggest that a review committee be formed in every investigative agency which should assess the work of the probe. There should be a proper utilization of manpower resources also. Transfer and posting should be done without fear of favor. That's the quote from Chandra. NCB is often accused of giving more importance to celebrity or high-profile cases because it makes headlines. That's the Crime Bureau, the Narcotics Bureau. Since the murder of actor Sushant Singh Rajput, NCB has investigated the link between Bollywood and narcotics. Riya Chakrabarti, Deepika Padukone, Sara Ali Khan, Rakul Preet Singh, Aryan Khan, well, the list is too long. Umakant Mishra, former Assistant Director of NCB, says, the Narcotics Control Bureau can never say no to investigations. The drug amount may be small or large. The NCB is bound by law to do the probe. It is altogether a different matter that when high-profile cases are being dealt with, media coverage is high. In cases involving celebrities and other well-known figures, the investigation can also be influenced. Court processes may also get influenced, but these are rare instances. One positive aspect of celebrity cases is that it highlights the misuse and ill effects of drug abuse. Recently, NCB dropped the Aryan Khan case and 5 others from its original charge sheet in the drug case, citing lack of sufficient evidence and shortcomings in the probe. The Union Ministry of Home Affairs asked the government to probe former NCB officer Samir Wankade's shoddy investigation of the case, and he was transferred as well. Later on, NCB Director General S.N. Pradhan reviewed the functioning of the agency and directed that officers should only concentrate on big narcotics cases and drug cartels, prepare strong cases backed and ensure convictions of the accused. The smaller cases of drug consumption may be followed up by police, he said. Umakant Mishra responded to the NCDG comments. He's responding to these comments. He says, I welcome these comments, but I have reservations. Can the NCB deny a probe if it gets drug-related lead? Can it ask the police to take up the case? I don't think so. It sounds good as a policy statement, but it has practical problems. There is an issue of fair trial too. The DG has also said that since they didn't have sufficient proof in the Aryan Khan case, they chose to drop 6 names, including that of Aryan, in the charge sheet. Investigating agencies sagas, of course, takes its course, the police force as well. Political use of the police force by state governments has been an established fact. Political use of police force has negatively impacted federal ties and law enforcement as well. Checks and balances within the police system has weakened. In 2006, Prakash Singh case, the Supreme Court gave its historic decisions regarding police reforms. 18 years down the line, nothing much has changed. The states have not complied with the court's direction. Laws like UAPA, Arms Act at the grassroots level also become the cause of police excesses. Ved Bhagwan, former IPS, says, I quote, investigative agencies have always been in the dock. The political parties use it to their ends. The probability of misuse of investigation exists because an element of discretion is present with the investigative agencies and the government. However, the agencies follow norms, rules and SOPs in their investigation. If there is any bias in the probe, the court of law can always interfere and pass strictures. Each FIR has to be presented in court and the court can take a call on it. In cases like Dholakuan encounter in Bangalore and the Bangalore rape cases, the courts have come down heavily on erring officials. Strong laws like POTA, MISA, TADA, etc., and many of them have also been abrogated. Courts have passed directions to improve law implementation. It's a continuous process. The reins of bureaucracy are in the hands of government. If the government wants, it can use the bureaucracy to its narrow ends. So, what options are available for an honest officer if he is forced by the government to obey a political order? Pillai responds, I quote him, if the law and order is concerned, then there is a slightly closer relationship as the government of the day is responsible for law and order. In cases related to investigation, the officer should have the full responsibility, and if he finds that his hands are tied down by any instruction of central or state governments, then he is duty bound to put in writing his protest. If he is shifted from responsibility and a more pliant officer is given charge of the case, then he can approach the court. N.K. Singh agrees with Mr. Pillai. that if an officer is pressurized to do wrong by the government, he can point blank refuse. I have done so. This many times in my career. The CBI selection process includes Prime Minister, the Leader of the Opposition, and the Chief Justice of India. This ensures impartiality. However, now as the norms of service of CBI Chief have been changed, the ordinances promulgated on November 14, 2021 paves the way for an incumbent director of the CBI or ED to get 3 extensions of 1 year each. This promotes pliability. All conflicts ultimately reach the courts. It is the final altar of appeal. Though the courts of law are the ultimate arbiters of conflict, it is severely overloaded. Hence, it is incumbent on the investigating agencies and the government to stick to the ethics of governance. Justice Chandra concluded, the courts can't take all the responsibility of the probe review. It is already struggling with the 3.50 crore pending cases. There is immense pressure on judges. It should be the onus on investigative agencies to maintain the sanctity of the probe. We should include 2 experts in the CBI Chief Selection Panel. In fact, many practical changes have to be implemented, and everyone should own responsibility to maintain the inviolability of law and the process. If the investigative agencies are working today outside their purview and the government is not following ethics of governance, then the responsibility falls on the courts to instill discipline. However, in a democracy, the responsibility to uphold the sanctity of the Constitution and law is binding on participant actors, and therein lies the solution to a more regulated and ethical functioning of central investigating agencies. The lesson in all this is that the investigative process has itself become the punishment. This is your host, Editor Inderjit Badhwar. Until next time, goodbye for now.
India Legal, stories that count.